and revive the judicial sinking image.
Thank you, Honorable Chair. I think the image of the judicial service has gone down. A lot of people have a lot of problems with the service, particularly with regard to the fact that cases keep so long in courts. People go to courts hoping their cases hoping that their case will be heard within a very short period. And cases, but there are some now. The average number of years that a simple civil case can stay in court is about 3 years or 4 years. There are some cases that have been in court for so long. There are also criminal cases, as I said earlier, where people are facing trial over a long period. All these affects people's confidence and trust in the service. But as I said earlier, some of them can be tackled because they are institutional problems. Like, we have vacancies for as many as 116 magistrates. We need to fill 116 courts. We don't have personnel. There are some courts that do not have infrastructure. I mean, you go to the courts and then the buildings are in very serious states of dilapidation. I remember last year, the District Assembly, over the past 3 years, the District Assembly Common Fund sponsored the building of about 100 courts together with their residences. But it's still not enough. We still have some of these courts built but not occupied because we don't have the personnel. But that is not to also mean that we should throw our hands in despair and say that we can't do anything about it. Admittedly, there are some cases that do not move fast as a result of, as I said earlier, the technicalities associated with our rules and other things. But we also recognize the fact that there are some judges and magistrates who do not put up their best. And all these add to the creation of backlogs. And I also mentioned earlier that people are now too eager to go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up, that we also want to encourage ADR. I was at the ADR week in Koforidua, and the reports that they gave us that of about 600 cases that came, about 470 or about 480 they were able to solve them through ADR. And so we realized that if but it is still not, people still do not know so much about the ADR. So if people are sensitized enough about ADR, they will embrace it and then leave the courts for more serious matters. The way it is that there are some people who, no matter what, who want to go to the regular courts. They want to have their pound of flesh. But so it's a combination of a lot of things that lead to this backlog of cases, and that is what people's confidence or trust in the judiciary going down is more as a result of the fact that their cases are not heard early. There are some people who also have lost confidence in the judiciary because they say that judiciary is corrupt. How they come by that decision, that statement that judiciary is corrupt, I have made mention of the fact that the judiciary is as corrupt as the people who man it, and the people who man it are as corrupt as the ordinary Ghanaian. The ordinary Ghanaian goes to the bank and he is told that give your money to the teller, otherwise you may have your money stolen. He goes, and instead of being in a queue for just 2 minutes, he sees somebody sitting down there, or somebody recognizes him and says, "Oh, I'm a teller." And then he takes his money to go and deposit for him. Before he's aware, the man has stolen his money. The ordinary Ghanaian goes to the courts, and I tell you, if 100 people evince the intention that they are going to see a judge because they have a case in the court, less than 3 of them will be able to go to the judge personally. They will go through his girlfriend, they will go through his wife, they will go through his friend, they will go through all kinds of people. So anybody who they think is close to the judge is game. You go and give your money to a court clerk or anybody. There are some people actually loitering around the courts who the court clerks, they know them. We have people we call bail contractors. All kinds of people patrol the courts. So you want to see why you want to see a judge because you have a case there, only you know. And then you cannot go and see the judge because you are afraid. Then somebody tells you, "Oh, that I saw the judge talking to that lady. So it is his sister, it is his daughter, it is his girlfriend. So go and see her." So people give their monies to people, and then they don't even, once they have given the money out, they have bribed the judge. They have given, they are okay. So such people go about saying that, "Oh, the judges have taken their money." And once the judge has taken their money and they get their judgment, they are okay. While the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad notes among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline in then we can tackle it. So if we sensitize people about ADR, that there's not every case that should go to court, mainstream court. And we sensitize people about ADR. People will go there. The backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad notes, if we catch the bad notes and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disciplinary measures. The Judicial Council is going to take up this up because we already have a complaints unit, but people don't even complain there any longer because sometimes they feel that they have complained and they don't get good responses. I'm going to reignite the whole thing, reinforce it, so that, because we should get, the judiciary should be able to get the confidence of the people back. Otherwise, we might end up having people say that, well, I'm not going to court, I'm going to do what they call mob injustice. Thank you.
Any further question?
Thank you. Having listened to you, I want to find out, will you reinstate the electronic case assignment, which was introduced to keep judge shopping and later discontinued by your predecessor?
I think I am all for it. I am all for it. It is going to be reintroduced. I think for about 2 or 3 years now, we have a situation where applications that are filed do not have return dates. You go there, they say date to be fixed. Immediately so we found there were situations where a case comes before us, an application, even before the Supreme Court, an application comes before the Supreme Court, and we realize it is virtually moot because the application, which was actually time-bound, had date to be fixed on it, and it has been fixed for the past 2 years. So immediately I came, I said that one was wrong. So every case that is filed, every application that is filed should be brought to my attention so that we fix, because most applications are time-bound. And so I did that for some time. And now things have stabilized. So we don't have dates to be fixed again. We now have dates given to applications that are fixed for hearing. So with substantive cases, we are going to reintroduce it used to be there until the machines broke down, the system went off, and then it was allowed to fall into abeyance. Now we have actually started doing the electronic.
Thank you very much, Honorable Umar. Do you want to ask your last question? Yes, please do.
Thank you, Chairman. My Lord, there are persistent concerns out there that the current process of appointing judges and chief justices give excessive influence to the executives. What reforms, if any, would you recommend to make the appointment process more transparent.
Thank you, Honorable Chair. I think I'm the wrongest person to ask this question because, as I said, I have had my elevations across political divides. But I think the current system, for us, it follows the Constitution. If the Constitution is going to be amended to give us a different mode of appointment, then that's it. But the current system with Superior Court judges up to Court of Appeal, they are appointed by the Judicial Council, by the President, in consultation with the Council of State on the advice of the Judicial Council. And the Judicial Council is made up of persons, apart from 4 nominees of the presidency. We have the JUSAG represented, we have the lower bench represented, we have a High Court representative, Court of Appeal representative, a Supreme Court representative. We have institutional representatives like representation from, let's say, the police, the army. These are all members who come from different backgrounds, and they have contributions to make. And they advise the nomination or the nomination and appointment of members of the court up to the Court of Appeal. So, and when it comes to even selection of nominees for the president to appoint, we have persons who are mentioned by the Attorney General, who is a government person. But then we have the Chief Justice also bringing nominees. And then we have the Ghana Bar Association also bringing nominees. So what happens is that there is a list produced by these 3 groups. The Chief Justice normally bases his or her nominations on seniority at the bench, performance, and other things. Maybe if a person has disparate proceedings against him, that's a different matter. Then the Attorney General also nominates, and then the Bar Association have the chance to nominate persons from the bar and also from the bench. The idea is that the bench, our performance is also always reviewed by the lawyers, by the bar. So we have a situation where when these 3 lists are produced, you find a particular, let's say we want an appointment to the High Court. You will find a particular circuit court judge whose name appears in the list of the Chief Justice, in the list of the bar, and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges. So the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temperament and the demeanor and everything that can make them judges. It's not every good lawyer who can be a judge. So sometimes we on our own. I have mentored so many lawyers, and I'll tell you, I can tell you that you will be a good material, so apply to join the bench. So even though the Chief Justice normally nominates from the people from the bench, the Chief Justice could also nominate somebody from the bar. So when these nominations are done, it go to the presidency, and then even though the wording is that it is done on the advice of the Judicial Council, and the Supreme Court has said that the Judicial Council's advice doesn't bind the president. Nevertheless, I have been a member of the Judicial Council, and currently I am its chair, acting chair. If 40 people go through our net at the Judicial Council, less than one or a maximum of 2 may not be taken by the presidency. So the advice, we say it doesn't bind them, but in reality they listen to us because the president knows that it is the Chief Justice and the Attorney General who deal with these people. So if they make this advice, and so with this kind of nomination from these 3 people, how people can talk about political, I can't really understand. With the Chief Justice, over the years, this is how it has been done. It is I think, well, I know in Kenya, things are done differently. The Judicial Council or Judicial Commission is very empowered. But whatever it is, the president has a say. And at least that is what our Constitution says. If Ghanaians believe that the Constitution should be changed to give power to other persons, other bodies to nominate their Chief Justice or the President, Supreme Court judges, then they can lobby the Parliament for honorable members to have a look at it.
Thank you. Honorable members, on this note, we will then proceed to take questions from members of the subject matter committee in line with Order 217. Honorable members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honorable Bede Asidin, you have the floor. The name is Bede Asidin.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination.
Thank you.
And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came out to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as you have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment in spite of all that. We have tried to explain that even though...
Honorable, you are violating our rules. Please ask question.
I'm asking the question. I'm laying the... My mic is... My Lord, I want to find out from you, do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. You asked me whether I think the current arrangement is okay or it should be adjusted. I think that the current arrangement in football, we say if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, you see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, as you rightly said, the nomination and appointment and everything is done by the President. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's what I'm saying, that as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges, and that is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules, and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes?
My Lord, my supplementary question is that, having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my Lord, your answer to the supplementary question.
People suspect that In the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with, but as far as I'm concerned, as I said, persons have been promoted on the advice of the Judicial Council. If 40 people, names of about the current list, on the advice of the Judicial Council, 41 persons' names were sent to the presidency. And only 4 out of the 41 names were taken out. And even only on the grounds that they had not finished with the background check, as at the time they were because I was sitting on I was pleading with the president that we needed to have these people sworn in so that the legal year could begin with the courts full. But the president, they had not finished with the national security clearance for all of them. In the long run, out of 41, recommended by the Judicial Council, made up of members of the bar, members of the judiciary, members of the Attorney General's representative. These 37 out of the 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how will I be able to convince such a person that it's not the president actually who put the 37 people there? We did. He only took our advice. So it is not as if people's suspicions are going about that. You cannot go about trying to assuage people. You can do that. People will still have their suspicions. One of the questions that I got was, people are saying I got my nomination as a result of 2013. I have explained my way. If people still have that feeling, can I do anything about it?
Thank you very much. Yes, any further questions?
Yes, Mr. Chairman. My second question, my Lord, you have dealt with it partly, but I'm bringing you another angle. Under Article 154 of the Constitution, 1541, if we approve you, which we are going to do, you will become the chairman, because I'll vote for it. You become the chairman of the Judicial Council. And under Article 154, you are enjoined as a council.
What is your question?
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, the Supreme Court will interpret the laws, and all these come as a result of adjudication. As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings. Like, as I said, we mentioned the complexities of the rules. We talked about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways, is only within Accra. And also, even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year. All the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. It is very, very, very important to recognize that apart from the judges, the judicial system is not made up of only superior court judges. Superior court judges, by virtue of Article 71, have their salaries decided by the presidency through the committee and then Parliament. Whilst the lower bench have their salaries tied to normal civil servants. And worst of all, the JUSAC, who actually form the bulk of the judicial service. As a matter of fact, if you look at our numbers, the judiciary made up from magistrates to the Chief Justice, we are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 70, Article 71, are the High Court of Appeal and the Supreme Court. We are not known more than 230 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judicial service. So we also have to think about reforms that should affect the lower bench in terms of salary, in terms of working conditions. Because whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, even some of the High Court judges, even in some regions, regional capitals, they don't have accommodation. As for the magistrates and the circuit courts, the least said about them, the better. Because you go to some places and they are renting the most beautiful house. And if before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is almost always in your court. So you find it impossible to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about the staff. And that is what I mean to do. I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
Chairman, that will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and asked you, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process because there are a number of suits pending challenging the removal of the previous Chief Justice. They're asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think yes, it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing. And as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment of to the position of a Chief Justice, vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Baffoe versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Baffoe versus Bank of Ghana, Cito and other things came up and said that that was right. That was, but the learning now, particularly after the case of Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood, but a writ, when we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, when President Mahama was declared, and it was sworn in on the 7th of January 2013, it never prevented His Excellency Nana Dankwa Akufo-Addo from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that it was, the judgment should go the other way, and that the president should step down for Nana Addo Dankwa to take the seat, that would have been the order of the Supreme Court, and it would have been enforced by Article 1 and 2. The same thing would have happened in 2020, when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to be, can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice.
There's no
and
court
there's
order.
no court order restraining Parliament from processing the nomination of the president.
There's no court order.
And you are here because we have summoned you to come for us to process you.
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here. They made it in
if this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanels judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and then move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, Then he goes to sleep, waiting for the case, the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within 2 weeks to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneling. The Chief Justice doesn't, seriously, but for the social media phenomena in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case, we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. That is what, but that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. So it is ripe. When you file an application for injunction today and they fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond, all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching and procedure to the minority. I'm actually asking the questions on their behalf, just so that they see that we're not running away from anything, and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he will give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Agyeman. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is a time in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who access the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April, 1974. 1974 provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter, and you are part of the case. Today we are still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case. But I mean, you're not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes, I mean...
The court was happy that they had finally resolved the matter. It was basically a land matter. But what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had been cases like that, and I remember there was a time the honorable Chief Justice.
So basically, my lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then to Court of Appeal, to the Supreme Court. That's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, I mean, Honorable Chair, I agree with you. But it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3,
Yes.
attempts to get justice,
yes.
and if at the 3rd attempt you are not satisfied, you just have to live with that, and rather work on the quality of the courts, so that by the time you do 3, anybody looking at the outcome at the third layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources.
Yes,
Can't we just cut down the number of layers?
That with all due respect, that will be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body, whilst we have the Supreme Court actually serve as a constitutional court?
Absolutely.
Because there's too much caseload at the Supreme Court level, which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the US, like South Africa has? What's your thinking? In view of the discussions going on about amending and reviewing our Constitution.
The Honorable Chair, this is a very interesting trajectory that this question is taking. People, in answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been, that whether we have a Supreme Court of 10, like 9, like America, or we can go to the minimum of 1 plus 9, that is 10, as our Constitution provides, and not go up, is dependent upon the jurisdiction of the courts, the Supreme Court. As you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts where civil cases or whatever, can go all the way to their Supreme Courts. But when you come to the federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal, review jurisdiction, we have appellate jurisdiction as far as the chief justice matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated because we deal with cases, as you are aware, there is a criminal case, Ali Kasina, started in my village at Goso, and it ended up at the Supreme Court. We have cases, civil cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have magistrate court cases from the magistracy traveling all the way to the Supreme Court. And we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, have been granted by the Constitution that a person has a right to go all the way to the Supreme Court, people are prepared to, and now, you see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. Then if you are doing a case, the slightest thing that anybody does, intellectual appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You find that about 35 of that number of years happened in the lower trial court. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submissions of parties, and then the ruling that is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial court, one, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that, no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where, finally, even where proceedings were supposed to be adopted, you'll find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this, like that. So you find that they cannot, nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, you know, that one alone is enough. But as I said earlier, there must be a way of tracking cases so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected, and he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long, like this. You see, when cases were given to me, in one particular instance, a file as big as this. It was scary, but I tried to take my time. I had been assigned by the Chief Justice. I tried to take my time to, as it were, arrange the processes to filed. By the time I got to the end, the file was as thin as this. This file, which was as big as this, carried more than 100 hearing notices. More than 100 hearing notices, all piled together like that. So by the time I selected the statement of the writs, the statement of claim, the defense, and then what did they call it at the time? Application for directions. We had a very thin file to go on. Then, one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter. There was a ruling. That was an interlocutory injunction. The case has ended. It is going on appeal. If you are prepared the record of proceedings, do you need to include the application for injunction and all its documents? But all these things will be included, making a very bulky record of proceedings. And it is the clients who pay, for the parties who pay for the record of proceedings. And each record of proceedings, each page is sold at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Rickett-Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually 2, just a view. My Lordship, PaulBaffoe-Bonnie, congratulations.
Thank you very much.
Looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, just a view, actually, that I want. Do you take the view that as a country, Ghana, we are churning out too many lawyers in terms of people going to law school? And if that is your view as well, because it's a view of, a school of thought, if that is your view, would you support downsizing the intake to the law school as well as those who go through the bar? Thank you.
Thank you, Mr. Chairman. Honorable Chair. I think I don't agree, I don't share that view that we are churning out too many lawyers. Actually, the word churn gives the impression that we are not training, we are doing substandard work by that the products are substandard. But that is not the case. We are also not overproducing. Actually, you see, if you go into history, throughout the whole period that we have had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together from 18th century, Mensa Saba and all that, we're not up to 15,000. 15,000. And that is from 18th century. Out of this, a lot of them have died. A lot of them have migrated. So currently, the people in Ghana who are lawyers, despite the numbers that you see being called to the bar last year and 2 years ago, the numbers are not up to 7,000. The number of lawyers in Ghana are not up to 7,000. And out of this 7,000, less than 5,000 are in private practice. Less than 5,000 are in private practice. And what I mean by private practice is, for example, those who are on the bench are also part of it. Attorney generals, and then the practitioners. That doesn't include those who are in the banks, Bank of Ghana and other places. All those are people who are not even in practice. So you see, if you take the number 5,000 as lawyers in Ghana, and you measure it against the population of Ghana, you have a ratio of 1 to 7,000 citizens. 1 lawyer to 7,000 citizens. Nigeria, they have, I think, 1,500 or 2,500. The UN sustainable is that it should be 1 person to 250. So you see, we are way beyond. We are way above what should be the right thing. And we also have situations, you know, the law is such that the district assembly law, the local government act, expects every local government to have a legal department. And when they say a legal department, not just a lawyer, a legal department. If a legal department, then they should at least have more than 1 person. Every local assembly, House of Chiefs, all the houses of chiefs. So we have lawyers. We actually need more lawyers. If you are deceived by the number of lawyers you see in the law court complex or plying their trade in Accra, you may be deceived into thinking that there are many. But go to Kumasi. Kumasi has a population as big as Accra, slightly lower than Accra. Or Ashanti region is maybe even bigger than Greater Accra. But the number of lawyers operating in Kumasi, from Kumasi, are 305. Kofori, they are 110. Secondly, and my honorable will tell you the number of lawyers who are in Tamale, Bolga, and Wa. You see, we don't have enough lawyers. So even the ones, the number that we have a maldistribution, geographical maldistribution. So if you see lawyers, and there are so many of the lawyers that came out, who were called to the bar, the people who were called to the bar very recently, there were about 800 of them. I can assure you about 200 of them may never ever step in the courtroom. They just, the headmaster of my school, the best secondary school in Ghana, Korogo Master, is a lawyer. And he's been a lawyer for the past 6 years. I asked him why he went to read law. He says, when he retires, which will be doing at the end of November, then when he retires, then he will pick his law, he'll go and do galamsey. No, not the galamsey. The lawyers understand legal galamsey.
Are you talking about galamsey in law?
In law, yes.
Very well.
So you see, and then of the 5,000 lawyers that we have in Accra, so many of them have run to Parliament House. They are politicians now. They don't even come to court. So my honorable chair, they are not many. As a matter of fact, I believe that we need to expand. We need to expand the admission so that, because now a lot more people are doing the LLB and they are not getting the chance to go to the law school. So there is even, there has been discussion with the current Attorney General, and then we are thinking about a situation where I think there's a government policy in the offing that is aiming at farming the law school program to various faculties so that we get rid of the admission, the entrance examination, and then we find ourselves, everybody who has done LLB can go and do the law. At the end of the day, there will be an examination, and then people will pass out. People will come out as lawyers. So to answer your question, I don't think that there are many lawyers in Ghana. We actually need more lawyers.
Thank you very much. Any further questions?
Yes, Mr. Chairman. Thank you for the enlightenment, my Lord. My second one is also a view. And now let's turn to the Supreme Court itself. Ghana's population is about 34.5 million. Let's say America's population is 10 times that size. We have 19 judges of the Supreme Court here in Ghana to a 34.5 million people. We have 9 to America's 345 million. Isn't that we have too many judges in the Supreme Court? What is your view on that? Thank you.
I thought I had answered this question. I thought I had answered this question.
Honourable members, order.
I thought I had answered this question, but Honourable Chair, I have to repeat what I said. America doesn't have 9 Supreme Court judges. It's the federal state of America that has 9 Supreme Court judges. America has about 351 Supreme Court judges all over the 51 states. You see, and the American Supreme Court, that's the federal Supreme Court that you are talking about as having 9, has only one jurisdiction, and that is interpretation of the Supreme Court, the Constitution of America. of the U.S. That is, they are what we call a constitutional court. So, but Ghana, our Supreme Court has, as I've said, appellate jurisdiction. The case, the 40-year case that honorable member talked about, finally ended at the Supreme Court. I'm sure even if we were to go into archives, we will find that from there, from the General Supreme Court, the person might have gone or up for review. You see, so the Supreme Court has so many jurisdictions that if we decided to keep numbers at 9, we would not be able to work. We will not be able to work at all. The only thing that we have to, there are two things. And either we increase the numbers, 19 may be all right for now, but the way things are going, the way cases are coming up, and the way we are thinking of AI and other things, we may see now cybercrime, everything. There are modern areas that are coming up that we have to empanel judges to deal with. The way things are going, if we don't take care, we might end up with about 25 Supreme Court judges. The surest way of avoiding that calamity is for all of us to come together and maybe through the Constitutional Review Committee, reduce the jurisdiction of the Supreme Court, the various jurisdictions that we exercise. Like Honorable suggested, we could say that every appeal should end up at the Court of Appeal. There shouldn't be interlocutory appeals. There shouldn't be that. There are so many things that can be taken off. If we say that you cannot start any, because you can't start a presidential petition in any court apart from the Supreme Court. By an ingenious way of interpretation, even though all cases can end at the Supreme Court is said that parliamentary petitions can go only up to the Court of Appeal. That was very, very ingenious. And so parliamentary petitions end up at the Court of Appeal. If we could find a way of putting into the constitution that we want to craft for ourselves, so that cases can end at the Court of Appeal. Or, for example, criminal cases can only end up at the High Court or the regional tribunals or whatever. Then we can start thinking about reducing the number of Supreme Court judges. Otherwise, we should be prepared for a situation where we can have 20 or more Supreme Court judges in future.
Honourable Member, do you have any more questions?
No, Mr. Chairman. I just want to thank my Lord, and then I wish him well. Thank you very much.
Thank you very much.
Thank you, honourable members. My Lord, our revered guest, it's now my turn to ask questions. And by our practice and procedure, I don't have limit to the number of questions I'm supposed to ask. However, I have sat throughout the proceedings. I have listened to all questions asked and answers provided. I do not have any question for my Lord. Honourable members, I will then proceed to congratulate my Lord on his nomination as the Chief Justice. And before discharging him, recognize and acknowledge the revered guests, which I will do not in any order, but I will start from the guest list of the honorable nominee. We have Director General Prison Service, Patience Baffoe-Bonnie, a spouse of the nominee. Then the following people are the children of the nominee: Sandra Elizabeth Baffoe-Bonnie, Major Felix Baffoe-Bonnie, Engineer Eben Leslie Baffoe-Bonnie. They are the children of the nominee. Then we have brothers and sisters: Mrs. Georgina Konedu Kusi, former Council of State member. We have Peter Baffoe-Bonnie. We have Mabel Baffoe-Bonnie. Then nephews. We have Justice Baffoe-Bonnie, Enoch Baffoe-Bonnie, and Dr. Kofi Bonzi. Family. We have Mary Nikwe, Rosemary Boafo, Commodore Faustina Anoche, Kwame Asaribuedu, Jefta Apau, Esquire. Then we have the representative of His Royal Majesty Otumfo. We have Nana Sampamahini. We have Nana Amantahini and Amantahini. Anantahini. Forgive me if I don't pronounce it well. Typical Aigbe boy pronouncing three names. Then we have Nana Dr. Abura Boatin, Nyinahini in the Ashanti region. You are welcome. Then we have Reverend Father Akes, Christ the King. Reverend Pastor Tete, Assemblies of God. Then we have all students of Konongo Odumasi Secondary School. We have Felix Abuaji, Esquire. We have Justice Kusi Minka, Esquire. We have Koku Chiramantin, Esquire. We have Esuo Yao Benin. We have Captain Collins Fosu. We have Kwame JB. We have Kwame Ousu. Honorable members, we also have Marietta Ajewa Brew. The legal counsel to His Excellency, the President of the Republic of Ghana. We have Benedict Bob Derry, Director of Prisons Operations. We also have Francis Omani Ado, Deputy Director General of Prisons in our midst. Honorable members, don't take offense in the event I do not mention your name. At the back, I have Nana Sangba Jafla II, Paramount Chief of Sampa Traditional Area, also representing His Royal Majesty Otumfo Osei-Tutu. We have Nana Bofo Ajay Chichikra II, member of Asantehini's delegation. Then we have Berima Yao Koda Opon, Monwurahini of Achim Ebuakwa traditional area. Then we have Togbi Teprehodo the fourth. I've eaten the okra, so I can pronounce this one very well. He is the paramount chief of Famfoga, the president of the Volta Regional House of Chiefs, president of the Volta Regional House of Chiefs, representatives from the National House of Chiefs, and is also a member of the Judicial Council. Then we have Nana Dr. Baffoe-Bonnie, the chief of Nyanahini. I think I have announced. No, you have 16. I've done it. Now, back to the tall list containing the Supreme Court, Court of Appeal, and other judges. My lords and my ladies, I will urge the Hansard Department to capture every name that I have pronounced here, preface it with my lord or my ladyship, if I don't pronounce it. We have Gabriel Poma, Justice of the Supreme Court. We have Avril Lovelace Johnson, Justice of the Supreme Court. We have Richard Ajay Frimpong, Justice of the Supreme Court. We have SKA, my very good friend, Asedu, Justice of the Supreme Court. We have another good friend, Justice Tanko Amadou of the Supreme Court. We have Ernest Gaiu, Justice of the Supreme Court. We have Henry Kofi, Justice of the Supreme Court. We have Yao Asari, Justice of the Supreme Court. We have Justice Senyo Jamape, Justice of the Supreme Court. We have Justice Bright Mensah, Justice of the Supreme Court. We have Justice Kweku Akabofu, Supreme Court. We have Justice Dennis Ajay, Supreme Court. We have Justice Battles Kujo, Supreme Court. We have Justice Hafizata Amaliboba, Supreme Court. We have Justice Johnson Mbila, Supreme Court. No, member of the judiciary. Member of the judiciary. Yeah, Judicial Council. We have Samuel Afote, Judicial Council member. We have Ambassador Ekuya Sana Danso, Judicial Council member. Then I have announced Togbi Teprehodo already, but he's here again, Judicial Council member. We have Dennis Eyiram Fome, Judicial Council member. Now we have Georgina Mensah Dacha, Court of Appeal. We have Jennifer Abnadazi, Court of Appeal. We have Kofi Akrowia, Court of Appeal. We have Justice Pamela Kranti, Court of Appeal. We have Yao Onyamiye, Jacobo, Court of Appeal. We have Shilaminta, Court of Appeal. Gifty Dacham, Court of Appeal. Professor Olivia Anku Chede, Court of Appeal. Dr. Bampuru, Court of Appeal. Dr. Enes Owusu Dapa, Court of Appeal. Jerome Noble Nkrumah, Court of Appeal. Anthony Opon, Court of Appeal. Jafta Apao, Circuit Court. Gifty Ajay Ado, Court of Appeal. Olivia Oben Ousu, Court of Appeal. Alexander Osetutu, Court of Appeal, and he's my classmate. Cecilia Davis, Court of Appeal. Mariam Samu, Court of Appeal. Mariam A.G. Jawara, Court of Appeal. Sam Obong Diewu, Court of Appeal. Lydia Osei Mafu, Court of Appeal. Charles Wilson, Court of Appeal. Ms. Rosemary Gazy, Deputy Director, Communication, Judicial Service. We have Mr. J.R. Ampon Fosu, Director, Communication, Judicial Service. Honorable members, all the Supreme Court, Court of Appeal, other judges are all my friends. We have Justice Yoni Kulendis, Justice of the Supreme Court. He is also my very good friend. Honorable members, you are all welcome. On this note, I proceed to discharge the nominee after a successful vetting, and to add that my Lord, Acting Chief Justice nominee, would surely hear from the committee. You are hereby discharged. Honourable members, I will ask the members of the committee to remain seated, and I was asked to add that in Parliament we don't clap, but we said here, here. Thank you all for coming. Honourable members, all the executives of the bar. I have seen the president and other members of the bar, former presidents. My own classmate, Kokujewu, you are all welcome.